What is the one funny thing about the concept of plea bargaining under Cr.P.C 1973? As you know, plea bargaining falls under Chapter 21A of the Cr.P.C, and if you read Section 265A, it says that plea bargaining cannot be applied to any cases where an offence has been committed which affects the socio-economic condition of the country or has been committed against a woman or a child below the age of 14 years. So it is either against a woman or a child below the age of 14 years or an offence that is affecting the socio-economic condition of the country. But when will you say an offence affects the socio-economic condition of the country? For that, we need to read subsection 2, which says that the central government shall by notification determine the offences under the law for the time being enforced, which shall be the offences affecting the socio-economic conditions of the country. Now, the central government did issue a GO long back in the year 2006. To be exact, it was SO 1042E dated 11th July 2006. I hope that is how it is pronounced. Now, as per this particular notification that was issued by the central government, there were a list of offences or laws which, according to the central government, affects the socio-economic conditions of the country. To be precise, the total number of laws that were mentioned in this particular notification were about 19. But when you read these acts, you realize that there are a lot of laws that are missing in there. For instance, there is the Arms Act, there is the Food Safety Act, there is the POCSO Act, there is the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act of 2013, commonly called as the POSH Act. Now you can understand some of these acts were enacted post the issuance of the notification in the year 2006. For example, the POCSO came in 2012, the Prevention of Workplace Harassment Act came in the year of 2013, but you also have certain laws like the Narcotic Drugs and Psychotropic Substances Act of 1985 or the Passports Act of 1967 or the Essential Commodities Act of 1955, the Arms Act from the year 1959 or the Unlawful Activities Prevention Act 1967, which is called the UAPA, and there is also certain acts like Prevention of Cruelty to Animals Act 1960. So there are multiple acts which are not mentioned under this notification, some of which came after the notification was issued, some which were already existing at the time of the notification. So in case an offence is committed by any person under these laws, then such person can still claim the benefit of plea bargaining because the same hasn't been mentioned by the central government in the notification. Whereas very similar laws and very equally footed laws have been mentioned in the notification. So whenever an offender has committed an offence under those particular laws, the 19 laws that have been mentioned in the notification, then the accused cannot claim the benefit of plea bargaining. So you can see the clear distinction here, and it doesn't make sense. For instance, you can look at the case of Prashit vs. State of Maharashtra, where the Bombay High Court dealt with a similar issue. The case was reported in 2020 ALL-MR Criminal 3416. The case number is Criminal Writ Petition number 1946 of 2019. The judgment was pronounced on 16/12/2019. In this particular case, the offence was committed under the Maharashtra Protection of Interest of Depositors Act 1999. The contention that was put forth before the court is that the particular law also falls or should be falling under the category of offences affecting the socio-economic conditions of the country. But the Bombay High Court took the view that since it was not mentioned in the specific notification issued by the central government, then the same cannot be said to be affecting the right of the accused to claim the benefit of plea bargaining. Additionally, here it was said that it is for the central government to determine which offences are to be excluded from the applicability of plea bargaining, since the MPID Act is a state legislation in the state of Maharashtra, and the fact that the central government did not list such an act in the notification, it was held that the designated court did not have the power to include such an act under the category of offences affecting the socio-economic conditions of the country. Unless the central government issues a notification in that regard, no law can be said to be excluded from the benefit of plea bargaining. You can also refer to the case of Sri Vinod Kumar Agarwal vs. CBI, where the Allahabad High Court also made a remark regarding the same. In this case, an offence was committed under the Prevention of Corruption Act 1947, and the trial court made an observation that the PC Act is excluded from the applicability of plea bargaining, and the central government must be amending the notification so as to include the PC Act in it. But the Allahabad High Court held that the observation made by the trial court is not binding on the central government, and the central government is independent to determine which offences must be falling under the notification and which must be excluded from the applicability of plea bargaining. Now, when you come to think of it, there are a lot of serious offences and serious laws which are missing in the notification. To begin with, POCSO, which is the most or one of the most important laws enacted after 2006. It raises the question as to whether the central government must issue a notification right now, amending the same and coming up with specific laws in detail so as to provide clarity on the same. But there's also this other issue that there may be state legislations covering important issues, and shouldn't it be the case that state governments are given the power to also issue a notification so as to ensure that serious offenders under state legislations cannot claim the benefit of plea bargaining? Can that be done? Let me know your thoughts in the comment section. It will be much appreciated if you participate in the discussion. Do share this with your legal community and subscribe to Lawyer Society for more of these interesting episodes. Check out our other videos from the channel concerning criminal law, property law, or matrimonial law. We raise such interesting discussions for you to learn from and for you to discuss, for us to engage in interesting legal conversations. So I hope this channel is useful to you. Thank you.